गैलेक्सी G6 Infinity कौन है?
We are live on YouTube right now. Okay.
अपना नाम बताओ नहीं तो मैं रिमूव कर दूंगा यार. Isha ma'am is here with us. Good evening, ma'am.
कोरोना वायरस जैसी महामारी की वजह से लेकिन बातों को भी आज नहीं है. तो ईशा मैम का म्यूट करो. ओए सॉरी डिस्टर्बेंस है.
सर एक रिक्वेस्ट थी कि आप बोलेंगे तो माइक क्लोज रखिएगा. स्पीकर वो उस पर जाएगा लाइव.
देंगे तो माइक क्लोज रखेंगे.
जी सर, आप ईयरफोन्स पे जो माइक रहेगा वो क्लोज रखिएगा.
Gautam sir, request Swati ma'am to begin. Here.
Hello.
Please begin, ma'am.
Request Manvinder Sanjar.
Manvinder sir, are you there? Yes, please.
Audible.
Okay. So I welcome all of you, all the students of Dharmashastra National Law University and the faculty, and most importantly, our very esteemed guest, Mr. Gautam Bhatia. As you all know, that Gautam Bhatia not need to be introduced, especially to law students. Nevertheless, I'll do this task. Well, now we read Gautam mostly on his blog, and he also happens to be a National Law School Bangalore graduate, and he has done his LLM from Yale, candidate at Oxford. We are presently reading his book that has come just last year, The Transformative Radical Biography in 9 Acts. And into the present topic that we're discussing, COVID-19 and the Constitution. Gautam has already written quite a lot on his blog and also in newspapers about the constitutional and other issues associated with the measures which the government has taken in relation to the outbreak of COVID-19. Much ado, I would now like to invite Mr. Gautam Bhatia to kindly talk to us. Gautam.
Thank you. I hope, am I audible to everyone? Yeah.
Yes, sir. Yes,
yeah.
sir.
I hope everyone's doing well in the middle of quarantine, wherever you are in the country. It's obviously quite hard to carry on normal functioning, especially for students during the course of this crisis, and hopefully we'll all come out of it soon enough. I thought it would be interesting to talk about the intersection of COVID-19 and the Constitution, because I think often it things work. It's only when in times of crisis, when things are stretched, when boundaries are pushed, that some of these issues that are otherwise theoretical, become clear. You do this is I'd speak for a bit, and then we can have this function where people can type in questions, and then we can have an interaction where I can answer questions that people send in as we go. So I'd just talk about a few things, and just to put some ideas in your minds. I think the first thing is basically starting from first principles, which is the structure of parliamentary democracy and what some of its basic features are, and how COVID-19 calls into question some of those basic features. So, as you all know, the Constitution sets up a democratic republic that, in accordance with parliamentary lines. So, basically, you have broad wings of state. You have the parliament, and you have, and the basic idea underlying this old idea, and that idea is that at no point should you, sorry, want to say something? At no point should you concentrate power in one source or in one official, and to avoid the possibility of there being too much power in a single hand that can overwhelm some of distributed power. different bodies exercise different kinds of power, very important role in checking each other. So bodies exercise review functions, they operate within their spheres. Other bodies don't exceed. So, in the context of parliamentary democracy, you have the parliament. So, the parliament is the elected body that represents the people through periodic elections at both the central level and the state level. And the parliament is the body that passes laws, in its assembly. It passes laws. The role of the government is those laws on the ground to administer, to govern, care of day to day regard to governance and administration. Sorry, did it sound so? Okay. Yeah, and the third body is that of the judiciary, and the task of the courts is to ensure that the other two bodies, the executive and the parliament, stay within their and therefore transgress constitutional limits. If the executive is doing something, legal backing for it, and not it's not acting in the air and so on. So these three bodies form these three wings of state that ensure that power is distributed and decentralized. Normally works. Now, of course, we all acknowledge that there are times when and this scheme might not be fully functional. It might not be feasible. So for those situations, the constitution itself is an emergency and has emergency powers. So what happens is that the government can declare when an emergency is declared, then rights can be suspended for a period of time, and basically acts as an extended parliament. Like it decides on a number of measures. It can take over the federal structure, pass regulations and laws that normally would be left to the state. The role of parliament is to ratify or to not ratify this emergency proclamation after a given period of time. So that's how the emergency structure works. The idea is that you give the government the ability to a crisis effectively, but ensure that so at the central level, what's happened is that there is the National Disaster Management Act, which you would all have heard of by now. The act was passed in 2005 in the wake of a couple of cyclones, and the idea was to be able to deal with disasters at a localized level, to mobilize resources to deal with those disasters. Now, what the central government has done is it's invoked this act, the NDMA, and the NDMA basically parliamentary committees that are designed to look into issues around public health and so on. And these parliamentary committees are formed. So these are all bipartisan, multi-partisan, and they can investigate what the government is doing and bring out reports. And thirdly, you have specific parliamentary questions that are put to ministers. So, now, what the NDMA has done is to ensure that none of these functions can be performed. So effectively, you have regulations coming in from restrictions, movement, gatherings, and so on. And again, there is no elected body can scrutinize or review what's happening. And then the last local level, you have Section 144 of the CRPC, which local police commissioners are using to impose restrictions on individual movement. So what you see is that you have these three levels of executive action: government, state government, and commissioners. And the nationwide lock, and there is no legal term like a lockdown. So the lockdown is not a legal term. There's no law that authorizes lockdown. Have is a number of executive orders at three different levels of state. Comprehensive action, gatherings, assemblies, and so on. Legal framework. And as I've said, one of the issues with that is that the elected bodies, parliament, state assemblies, have been bypassed. They have no role to play in any kind of scrutiny of these actions. That you have taken away one of the three wings of state. Therefore, in my view, more important for the second, the judiciary, scrutinize what the government is doing. Because if the judiciary also abdicates, actually there is no check at all, and you have fear all along that just one body is controlling and exercising all power. Right? Now, one good example of the role the court, Isha High Court a week or so ago, interesting order where there was a complete ban on the use of in Bhubaneswar, get groceries and essential items. The government was asked, has this ban been imposed? Said that because we are delivering all essential items on a door-to-door basis, and so there's no need for anyone to go out, which was found to at that point not yet have been the case. And so the court says that, look, you're talking about women, then it might not be feasible for them to go walking to get essential items. And so you need to have a tailored response where you allow private vehicles, these sets of people who may have certain to going out on foot essential items, and allow them to go out in their vehicles. And of course, if you think about how COVID-19 spreads, it doesn't spread through like a private vehicle. So you're going out in your own car, essential item, the risk of spreading COVID is minimal in that process. So effectively, what the High Court was doing here was it was applying the proportionality test. So it was asking, look, okay, the government has a legitimate state aim, which is to ensure that there is effective measures taken to combat the spread of the pandemic. So that aim is legitimate, that no one disagrees with. To combat that, impose the lockdown. Some countries like Sweden have gone a different route, but we all agree that decision is to be taken by the government, and it can pick to do based on advice. It's that again nobody's question. But what is under question is that a specific measure that may be taken to enforce lockdown might still be an overreach. It might still be something that is right to a disproportionate degree. Court comes in and asks the question that, look, is there a less restrictive way pushing this goal of yours? Can you enforce this both without infringing on rights to this extent, and if you can, then pick the less restrictive. That's what the Odisha High Court did. Again, in the UK regulations on movement. So in the UK, for example, they said that you can go out once a day, go out to buy essential items or to the hospital, go out in groups of more than two. Here is that you want to break the chain of transmission, that people can move, but people can't move in groups. Right? So there's again of making sure you are fulfilling the goal, ensuring that you aren't restricting rights beyond what you need to actually restrict them to achieve the goal. So that these kinds of questions, I mean, clearly the issue of whether a particular measure correct or not. It's a relatively easy case. You have more difficult cases when you have all these issues around the use of contact tracing apps that are being put in place, and get data on who is infected, who is not. Whether you can have an effective quarantine mechanism to ensure that everyone who is at the risk of infection. Right. One example, for instance, which came about recently, Karnataka government decision to put up the names and addresses online, people who had shown symptoms and were under quarantine, and to put them up online. Second was they had this requirement that everyone in quarantine has to basically take a selfie every 1 hour, send the selfie to the government to show that they are in quarantine, and that selfie can be geolocated and the timestamp and all that. So basically, the government knows that you're in your house and not going out. So there is the Maharashtra government's decision to stamp people's, I think, arms with a quarantine stamp that dissolves after 14 days. So then that goes. Now all these questions raise very difficult issues of overreach, of rights and so on. Now one argument is that look, this is the extraordinary situation, right? It requires extraordinary steps to deal with, and therefore there must be more deference to what the government is doing. Now that's fine. I mean, we can accept that. We can accept that you need to give more leeway to the government to take steps it deems fit to combat the crisis. But distinction there must be drawn. Court or a court that is reviewing these steps, right, obviously shouldn't be substituting its own policy wisdom. Right? That we agree on. What the court can do is actually ask some questions that will require the government to reveal the reasoning behind what it's doing. And often when that happens, see for yourself that the reasoning doesn't stand up to scrutiny. In this whole putting up names and addresses online, the fee requirement even is that you need to do this to ensure that people know who is symptomatic and who is who to avoid, and therefore spread of the pandemic. Don't see put these names and time. You basically created this whole stigma in the pandemic, right? And what that then entails, people who show symptoms, who suspect they may have COVID, will not be reporting themselves. They want to be subjected to this kind of an invasive measure, and they don't want to be stigmatized for it. There have been reports recently that people are not actually and reporting that they have symptoms. They fear being stigmatized for it. Be defeating your own point, right? If you're underlying this measure is to identify who has symptoms, pull them to self-quarantine so that the pandemic doesn't spread. It is defeated if they decide not to reveal that they have to do anything about it. Right? And so, is to actually ask, if you considered this, what have you decided to go ahead with such a scheme anyway? And of course, the government might then give a good reason, and the court then can accept that. Right now is that even those questions aren't being asked, and so effectively you have all these policies, these regulations coming and being imposed without the requirement of the government explaining why it's doing what it's doing, and therefore this whole idea that the government's actions must be backed by reason, arbitrary, that is being it's very difficult to actually see that, to check that. Of this that comes to, and this will be the last part of my talk, and we can move on to questions after that, is the link between and associated measures, idea of equality. And I've spoken about this before and written about this. I think it's really important because it often gets missed in the debates on what's happening. Is that, as we have discussed, different countries have taken different towards containment strategy of herd immunity, and then you have the lockdown strategy. So this is basically a policy choice the government has made to have a lockdown, and that, as we've seen, is fine. That is the government's decision. That's why we have these kinds of issues. The effect of the lockdown is not uniform. The lockdown disproportionately impacts people based on a number of socioeconomic indicators. A good example, we are all doing this on Zoom. We are having this seminar, this discussion on Zoom. Supposes both I and all of you have a functioning internet that can, up through which we can access Zoom. Not many people have that privilege to have fast internet that can sustain a Zoom call over. And so the educational sphere, the access to the internet directly impacts what do or cannot do during a lockdown. The basic example that you can see. Example. So one issue is there has been encouragement by the government that all people should work from home. Study in the US showed that the ability to work from home is directly proportionate to your income bracket. So the higher income you have, the more likely it is that your job description enables you to work from home. The lower is your income, the less likely it is that your job description can allow that. And so effectively, you are penalizing, harming very marginalized or vulnerable and who already struggle and to get daily income. They are suffering more. The answer to that is not that the choice of lockdown is wrong. That on the basis of the decision taken by the government, there is certain impact on a group of people. Then the obligation to mitigate that impact is also upon the government, right? And that's why you have this whole issue of what schemes must bring in. So again, for example, in the UK, whereby can basically opt into this furlough, and then the government will pay 80% the salaries of these of their employees, right? And there's been a big controversy over whether gig workers or not, and so on. If you think about it, next, consider, for example, Uber or Ola drivers. Drivers are of two categories. One category is those who, to one of them, you'll know this. One category is of those who own their own vehicle, right? So, and who do this cab riding as something to earn some extra money. That's one category of people. The other category is people who don't own their own vehicle, or those who have bought a vehicle by taking a loan, often from and then repaying it through installments. Now, for these people, to drive a number of hours in a day to be able to pay off, often be like 12 or 13 hours of driving a day just to ensure that they are paying off the loan. To have basically banned, right, people who are required by law to pay off these loans, depend on driving to do that, suddenly don't have the option, right? And that of the lockdown raises the whole constitutional question of equality right with the right to livelihood. Because for one section of people, work depends on physical movement. No longer are able to actually, right? And so then you have the whole idea of what are the obligations of the government, and what it's doing to another example of this came in the very controversial court order on free testing for COVID-19. An order that said that look, you need to have free testing, and the mechanism of compensating private labs future. That was the first order. In 3 or 4 days, the Supreme Court walked back on that and said that okay, actually this applies only covered by the government's Ayushman Bharat insurance scheme, and for the rest of the people, the government can decide whom it wants to include or not include in that. Basically, of the matter. Now, again, here you have a number of issues. So the first is that the ICMR guidelines decide on which testing can happen. So it's not that means that anyone who wants can walk into a private hospital and get tested. You still have to fall within the guidelines on what is the basis for testing in the first place: symptoms, contact with an infected person, foreign travel, and so on. So that's one thing. Now, secondly, the argument was made that you have this free testing, make it free for everyone. Then basically, because of the costs involved, there will be less testing happening because private labs will stop and doesn't have the money to them. It was made. Might be true, it might be false. Right? It may be the case, and making testing free would have the impact of reducing the overall number of tests and defeating the purpose by widespread testing. That could be true. It may not be true. Right? The issue of the price cap. Rupees 4,500 was the price set as the price cap on testing. The question is on what basis the price cap arrived at, especially given that in other countries testing is much, much cheaper. So what were the calculations that led to is the appropriate price cap to be put? And you have newspaper reports showing that there are many issues with how that was arrived at. Now again, what the court can't do, right? It can't do that. It's not, the court doesn't have economists, the court doesn't have healthcare experts. It can't decide, okay, tomorrow the price will be this. What it can do is say, look, government, as your price cap, in a country in which there is widespread poverty and lack of access to healthcare. So show us you arrived at this decision, and show us the basis on which you are saying that free testing would lead to a loss of overall tests. Now, if the government can provide a rational explanation to, then the court can accept that and say, okay, you're not going into the issue further. What has happened now is the court effectively is taking the government's claims at face value, not even asking for the reasoning. That is the problem. So again, going back to our original point about the role that the parliament and the courts have to scrutinize and to check what the government is doing. The idea is not to substitute for the government. The idea is not to the managers of the pandemic to take over the government's roles. The idea is to that in which all these decisions are taken, which to health and the right to equality is at least that basis should be made public, and the strength of the reasoning should be checked by the court and made open for the public to scrutinize. And so of the courts, in the absence of parliament, to strike down or to uphold what the government is doing, nuanced and a more subtle role, a democratic forum. The decisions that are being taken, this can be put to public scrutiny, happen on why and what is being done. And so that is actually as important as the court's role of striking down, upholding that what we think of as its basic role. It's also to facilitate dialogue because the other forum, parliament, has been completely bypassed. So that's what's not been happening. So in all the cases around labor and their situation, their status, giving them wages, sending them back home, free testing. So what we've seen is that the government comes to court, says a few things, and then kind of uh, uh, closes the case. Just leave you with a couple of thoughts, and then we can go on to Q&A and discussion. One is that to what extent has the language of war, we hear all the time that this is a war against COVID, and that we must defeat COVID as we would defeat like an enemy and so on. German health minister, interesting, a couple of days ago. This is not use language of war and soldiers, because that completely is besides the point. This is the public health we are dealing with in terms of public health, and in that sense, where you're fighting a war and therefore you refuse to question anything that's being done because it might hamper the war effort or might the war effort. So that's one thing. Is this whole rush to talk about this as a war? Is it causing less scrutiny of what the government is doing than otherwise would? And the second is that this whole idea that began with the PIL movement, that the government and the basically work together, and work in synergy or as a bridge, as the former Chief Justice said, right? If they work as a bridge between them, establish good governance or whatever, is that logic harming primary function that is held to account? Because if the court is more concerned with giving a seal of approval to the government or emphasizing that, look, we're all in this together, we're not like, nobody is an adversary in this, does that ensure that, or does that result in the court simply being unable to even correct the government when it is going wrong? And these are two things I think that really, in the context of the constitution, constitutional structures, in a public health crisis like COVID-19, where the temptation to actually concentrate power is very high and very understandable. Temptation that we should be actually remain as we normally are, even more. In a dissenting opinion in the emergency case, he famously said, look, authoritarian governments, because everyone knows the importance of resisting authoritarian governments, that's all fine. Okay. When you have good men, good women, men of zeal, have all the best intentions, to be overzealous in implementing them, rule of law and rights, because they think they're doing good. That's when Justice Khanna said we need to be at our most alert. Last 3 or 4 weeks has really proven that quite prescient and quite right. So on that note, I'll stop and we can open it up for questions, discussion.
Hello. Good evening. It was a very interesting discussion. There were few points that you made. I have one comment to make, and also I'd like to seek your opinion on that. So this lockdown we have been seeing online on Twitter, has raised so much of complex situations, complex issues for the marginalized. Seeing marginalized people, many living just thousands of kilometers to reach their home, and then meeting with accidents or dying midway. And there's so many cases like that. 2-3 days ago, there was a diabetic patient was denied some medication or food, and he died in the quarantine center. So there are many cases where we see that those who are voiceless are suffering the most. Apart from the specificities of lockdown, this situation as a whole expose the years old that is entrenched in our social structure, and also the anomalies in how any state, not ours for that matter, any state, how approach is towards policy decisions. So there are many subtleties which we might not be able to see otherwise, but they are exposed and they're magnified in this situation.
I think that's quite true, and I think that as this the issue of social and economic class has really come to the fore weeks. And so, for example, just a few basic things, right? So there has been in Spain, for instance, what they did was they moved to temporarily take over rules that you cannot effectively combat the spread of the pandemic without a coordinated public health response. Right? And you can see there's this debate about should healthcare be private or public. In countries like the UK, NHS fully ensures free healthcare to everyone at the point of need. Right. On the other hand, in the US, you have like a system that does not do that. Now, one thing that something like COVID reveals, that politician Bernie Sanders said, shows us that you are only as safe as the most vulnerable person, because that's how this pandemic spreads, right, from people. Even one person is unable to access effective healthcare, quarantine facilities, and so on, that becomes a risk to the whole community. So this whole idea of what is public, see, about the internet as public good, because the internet affects who can access education at this time, right? Healthcare, and so on. This is a constant battle between defining what is public and what should be subject to democratic control, and there should not be a price barrier to it, and what is private, or what through a profit motive subjected to the laws of the marketplace. And I think that what COVID does is to show you that border between the public and the private is a deeply contested. It's worth thinking very closely about that. Things we think should be private, should they really be private? Shouldn't they be part of the public sphere, and so on? And that, of course, affects class, because access to these goods and services is often mediated by money and by how much money you have. Public, then that is no longer like a barrier. So I think that is something to think about. I think the really interesting thing is that with COVID, you have all these really interesting ideas now coming out. Like the internet as a public utility, free broadband as a fundamental right, universal basic income. That fringe idea. Again, Spain has announced universal basic income. So all these ideas are really, I think, worth engaging with, because they show you how fragile that border between public and private really is. Okay, there's some questions. Positive rights obligation jurisprudence evolved by the courts in India is the reason for the courts in India not living up to the constitutional expectations here. Okay, so I think it's a little more. So I'm not sure if it's the lack of rights obligation as much as it is a lack of a clear understanding of the court's institutional role. Right? So what has happened since the PIL era, right, is on the one hand you have Article 21 being expanded massively, right? It has now like livelihood, right to health. It has all the rights you could want, on the one hand, and often to enforce it, the court really goes full on. Like it has a continuing mandamus. It effectively oversees the government's like implementing. It itself becomes an implementing body, and so on. So on the one hand, you have the court effectively becoming the executive in order to enforce rights. On the other hand, like this testing and these migrant cases, where the court suddenly says, look, the government is doing it, we aren't interfering. And the problem is you have no reasoning that tells you when it's A and when it's B. And so the court needs to, I think, really for itself a clear understanding that look, this is the content of the right under Article 21, livelihood, health, or whatever. This is the extent to which the court can intervene, either by holding the government to account, asking questions, on irrational action, and so on. And this is the point at which the court stops. It was to be made clear, right? I think this would then be resolved. Become, I think, very obvious what the court's role is and what the political process has to, deliver. And once you have that, it becomes clear when you go to court, why you go to court, and for what you're going to court. Don't go to court and try and do other methods of petitioning, of protesting, and of public engagement and so on. Right now, the issue is that people go to court for everything. But then the court says, oh, actually, it's fine, the government is doing well, and then it becomes an endorsement of the government. The problem is more that there is no clear sense of what the right's content is and what the court's role is. And that has to kind of, really, because we have this binary where either the court goes fully in and pulls up the government and begins, itself becomes the executive, or it completely has a hands off. And no balance, there could be before. So I think we need clarity on that point. The new amendments to the Epidemics Act. And I think that's risky because again, every time you have these new stringent laws that depart from established criminal procedure to serve a public good, what happens is that they play no role in actually bringing down the crime. But what they do ensure is that you end up victimizing and harassing people under these new kind of draconian standards. So I think that has to be kept into account based on our past experience with these kinds of laws. And the second is that it's unclear what competence the central government has to amend the EDA, because again, public health is a state subject. So there is I think, a competence question on how the central government has amended the EDA and put in this provision. So I think that is something that's worth thinking about a little more closely. I'm not yet sure what the answer is to that. Someone written that today we judge a government's constitutional conscience by analyzing the policies adopted by the government. Amid this crisis, we have seen how the voices of the subaltern were unheard, considering how the decision of lockdown was implemented without taking into account of migrants and daily wage earners. It reflects the government's short-sightedness, both in terms of democratic policy making as well as constitutional principles. Do you feel there is a need for a second wave of constitutional transformation by subaltern constitutionalism, ensure inclusivity along with solidarity while making policies for social justice? I think, of course, that's definitely true. I think the difficulty arises when you think about how to actually achieve that. For example, one thing that's there in some constitutions, for example, in the Kenyan constitution, there's actually a specific requirement of a constitutional requirement of effective public consultation before you pass a law with respect to the by it. The Kenyan parliament is not allowed to pass a law without first putting it through an effective public consultation and showing that it has taken on board the suggestions made, or at least considered them. So I think that you need to think closely about the structural mechanisms that you have to put in place to ensure that becomes a reality. Because I think one thing that we've seen over the last, I think, 4 or 5 years is that upon the goodwill of in authority, like whether it's judges, or government officers or politicians. What you need is strong institutions that direct towards goals of social justice. So if you put into place institutional and institutions that basically force government actors take into account concerns of marginalized people. For example, the Forest Rights Act, right? In the Forest Rights Act, actually to have the sanction of the Gram Sabha before you take over for your purposes, right? So you put into place these institutional mechanisms that require these principles, then you can go somewhere. That, of course, requires thinking very closely about what shape these institutions might question that regarding the dissenting opinion of Justice Khanna in the habeas corpus case, who has the say on deciding the boundary between authoritarians and good people who may become overzealous, as the judiciary itself has created a very vague idea of hearing to urgent matters, only which is not specified. It's a South African Constitutional Court. So, for context, South African Constitutional Court has set out a list of domestic violence, bail, and so on, that it says during a lockdown and everything else is at the discretion of the judge. I think that's correct in that the Indian courts have not what counts as an urgent matter, and so that has led to, of course, acquisitions of favoritism. Today morning there was an acquisition that by listing Arnab Goswami's was the double standard the court was applying, and that leads you to all kinds of acquisitions, and that's just like very bad for institutional integrity in general. So I think that's true, but I think the issue is not so much that you distinguish between authoritarians and good people who are being overzealous. I think the issue is that to get into the whole debate about whether X person is bad or good, you need to get into that very political debate. That look, even if we all agree that people are good, right? Government is good. We agree for the purpose of argument that they're all good. What we are saying is that people tend to overreach. The standard the court should apply or impose is the standard that good people tend to overreach, and what can the court do to ensure that the overreach doesn't happen. So that basically saves you from getting into a debate about whether the people in charge are actually good or bad, and that's the point I think as judgment, because I think remember that Justice Khanna wasn't actually in his judgment saying the emergency is right or wrong. Like, he wasn't saying that. Look, in an emergency, you can't do some things. You can't shoot people on a whim. That's what you can't do. And I'm not going to sit here and tell you the emergency was good, bad. That is the verdict of history, the verdict of the election, and we all know how that went, and so on. And the idea is that the court sit and decide the political question of good, bad, right, wrong. The court will say, we assume that you're good, but we will make sure that you can't, even if you say that you're doing them for reasons. Jharkhand High Court asked to donate to the PM Cares Fund and install Arogya Setu app as a bail condition. How far do you think this discretion is exercised? It is justified, not just within the procedural law framework, but also from the Constitution's point of view. In mind, extraordinary situations we are facing. Suppose these two, the fund and the app, were challenged in the court. Doesn't this step taken by the court already reflect a preference liking for these government measures? No, I think that's a really important point, and we saw with, for example, Aadhaar. So the Aadhaar challenge was stuck in court for 6 years. And in that time, the court already had passed an order saying that in a involving food grains, that you can use Aadhaar to, do some verification kind of stuff. Now, the whole issue again there is that, look, the court hasn't even heard, right? Like this is something that views on it at the final merit stage raises important constitutional concerns. Cares Fund and Arogya Setu app raise, and so if you basically to prejudge effectively by saying that, look, if you want bail you need to donate to the PM Cares Fund and download the app. If I want to challenge the app and I have some serious constitutional arguments against it, what faith do I have that you actually are going to listen to me with an open mind? It's very hard to, if you've already, expressed a very public liking for these things. So I think the court has to be much more careful about how it's doing things, because if it does this kind of stuff, then and again, given that the government is the largest litigator before the courts, and given that this was the court invoked to strike down the NJAC, the government being the largest litigator needs to obviously be at an arm's length to strike down the NJAC and say, look, we will appoint ourselves. But at the same time, you are, publicly expressing a preference for a government move that is under challenge or will be under challenge shortly. That is something that is not good. And of course, I think the court shouldn't be forcing people as a bail condition to, for example, donate to the PM Cares Fund. I mean, he may want to donate to some other fund, and he may not want to download the app because he thinks it's a privacy violation. So it's not for the court to decide that. I think so that, but yes, thing is, again, we are seeing this more and more. So you had this bail judgment from a few months ago, where the Supreme Court said that they can be out on bail if they do social service for so and so number of hours. And again, courts have said stuff on this, on similar things, putting all these bail conditions that have nothing to do with the core point of bail, which is that is the accused a flight risk or not? Tamper with the evidence or not? If the answer is the accused is not a flight risk, but with the evidence, you give the accused bail. That's it. Like, there's nothing more. The court shouldn't be like a moral guide. Right? The court's job is to apply the law and not to make moral statements on what is right and wrong. You have been a critic of the outcome oriented approach to determine the legitimacy of judicial intervention. Your thoughts in the relation to the expectation from the courts here in India? Yeah, so I mean, I think that we've been seeing over the last 2 years has been an outcome-focused approach by the court, where it appears to go more by if it thinks the outcome is justified or not, and less by whether the means taken to get there are right or wrong. And in this context, one thing I always tell people is that the constitution in Hindi it's Samvidhan. The word of Samvidhan is Vidhi, and Vidhi means like a path or a way of doing things. So the constitution itself, in its very, shows you that the path is as important as the goal, and you can't ignore one of the extremes to the other. I think that been doing to order of lockdown been expanded and interpreted vaguely by various state governments. Freedom of movement and imposing a form of curfew without actually having a law to back it. So I think like it's this is interesting because actually look at the regulations under the NDMA. There is no mention of individual movement being restricted. A restriction on transport between state borders and so on. The state regulations, you don't see anything on individual movement being restricted. There's a ban on gatherings. There's a requirement of sealing off, and so on. But there's no restriction on movement, and even the 144 orders, the ones we have seen. So effectively, the central level or the state level, there's no curfew. Really speaking, there's no curfew. So there's no. I haven't been able to find any specific prohibition on stopping an individual person to the house and taking a walk, for example, right? And hence, because as we've discussed, COVID doesn't spread through one individual in like gatherings and groups in close proximity. Seen is that no legal backing for a curfew, but from this kind of informally imposed curfew by the police and by local bodies have, I think, more or less various speeches by the Prime Minister, by the state chief ministers, the curfew without legal backing for it. So I think that again, it's just like this very grey zone of legality where you have all these vague orders and regulations, and you're effectively left to the discretion of police officers on implementation, and that's something that is very easily fixed. So that's quite a bad thing. The dissenting, this thought already happened. What are your views on increasing number of cases of domestic violence and basically of sexual harassment during the lockdown? How the government should manage it in synchronism with the pandemic? One is, of course, the support services that are available to like to domestic violence. And the other is a suggestion made by some who work in the area, which is that under the Domestic Violence Act, a woman who is being domestic violence, she ends up leaving household and living elsewhere while the case is going on. And of course, that can't happen during a pandemic. The argument is to reverse that. So the domestic violence happening, then it should be the other way around. The woman should be able to stay in shared household during that time. The way around. That's one suggestion, but there's been no move yet on enforcing that. I think there was one state government that said that we'll put in quarantine everyone who engages in domestic violence. I don't know what happened, but they took it forward. The government has done a survey of citizens regarding their health, and after that, given the data to an American company named Sprinkler, which is a data collection and analysis company. And now the problem is that if this company will sell this data to medical companies, then the government secretary also shared a stage with the official of this company, calling people to provide to government proper government processes. This is a big issue. What has happened with Sprinkler is a classic example of overreach. In that pandemic, you collect health data, obviously that we all agree on, but you're doing it without framework, without a data protection law in force, and without any limits on the use and what it can be put to. So what you don't want is or government actively being able to use this data, getting health surveillance in general, to then use it to insurance companies to frame policies around and so on. At risk. All these are like serious issues raised in the Kerala context. The Kerala High Court passed a pretty good interim order. Did the sharing of the information, and also I think said that you have to delete and de-anonymize, anonymize the information and then delete it after there's no more use for it. Today's interim order with the Kerala High Court gives you a good example of how a court can step in that the of individuals is not collected and used in a manner that beyond what is required to fight the pandemic and also safe. And we'll see if it's implemented, to what extent it will be enforced, and what the final judgment will do. I think that's still very much up for grabs. I think that actually the whole Sprinkler issue really the ways that a pandemic can be misused by governments to unwarrantedly on the rights to privacy and data protection. There is a need to amend the Constitution of India and have provisions for health emergency for better governance where pandemics have affected. Yeah, no, I think it's a good idea to include public health crises as a ground of emergency declarations in the Constitution. At the same time, we need to define it very clearly. So define very clearly what a public health emergency is, and so it can't just become a thing you to also to clarify what of actions taken emergency will be. So, for example, if you look at the Arogya Setu app, right? So one of the issues that has been raised by people, app that is brought in at this point of time to do contact tracing and so on, needs to have a sunset clause. When the pandemic is over, right, has to also be disbanded, and all the data that it has collected has to be removed. So basically, the idea is you can't use a public health emergency to put into place data collecting mechanisms, outlive the emergency and become permanent. That's the really key concern and key worry. So if you want to amend the constitution to have a public health emergency as grounds of an emergency, you also need to make it clear that measures taken to contain emergency will expire along with the emergency itself. That means, I think, if that safeguard put in place, case to be made for doing something like this. COVID-19 has normalized the deployment surveillance. In the era post COVID-19, do you think the judiciary will balance surveillance and citizen empowerment? I think that predict what the courts will do. It would depend upon, I think, good arguments and people like you becoming lawyers and telling the court that to ensure that civil rights are protected in these times. And so I hope that many of you will take the challenge up, and then the judiciary will correctly balance these two things. The court has the to interpret things as narrowly and as broadly as it can. Is the court justified to take a narrow approach in a particular case? Interpretation leads to the violation of human rights which are inalienable. I think it's hard to answer this without specific example in mind, but I think more broadly, I mean, the overall interpretive approach is that two ways possible of interpreting or a law. You pick the interpretation that will advance rights and will constrain the state's power, because of power is the crucial thing. Is powerless before the state. Have the choice of two readings, you will pick the one that would rights and limit its power. Of the DA of employees till July 2021 without imposition of financial emergency is constitutional. So this is a service law issue, and I have to say I don't know the answer and I haven't thought about it yet. Probably a service lawyer is better. So this question of freezing of DAs of employees. Of rejecting bail applications by Rajasthan and Bombay High Courts, judicial wrong hampering Article 21, at the same time justified by the inability to conduct proceedings. Courts are conducting proceedings that through video conferencing. Proceedings like any other can very well be conducted through such methods, and I'd say that requires urgency, specifically in the context of a pandemic where jails can become major reading grounds for bail hearings should be given priority in the general scheme. What is your opinion on the Madhya Pradesh political drama that took place a few days ago? Clear of the state contributing their duty towards the state and also maintaining the goals of the constitution. It was a political drama, and I think it took place at the wrong time, given that COVID was already very much in India by the time that. But beyond that, a political drama requires the ballot box to respond to it. So it really depends upon how the voters take this and if they punish those whom they think are responsible for it or not. So I think this is one thing the courts can't really solve. This isn't the problem the courts can solve. It's a political and social issue. How much is the situation, the federal structure, and to what extent can the center encroach on the powers of the state? And if any conflict arises with regard to the same, challenge under Article 131. One is that under the NDMA, the directions given by the center upon all the states. And so that, of course, affects federalism because, as we've discussed, health is a state subject. Now, the argument is that wide pandemic, and so you need to have a central response to it. Right? A fair point. So, to the extent that the pandemic India, and you need to coordinate the responses of all the states, you need to pass directions under a central law that lets you do that. Problem is that reach happens where to go be like implementing or overseeing what the states are doing in their own domains. The center ban interstate or interstate transport, right? Or, for example, decide if nationally important industries opened or not. So that's the things that the center does. How a particular district with send should one state or a different state or lockdowns, especially given that you've sealed off the borders, right? So now there is no danger of interstate. The states have to be given the right to decide for themselves how they want to tackle with the deal with the pandemic, right? And that problem arises. 131 is a hard one because for that the state has to show of a legal right, and that's the difficult part. There are a few pending cases that require that ask for this Article 131 to be interpreted in the broader sense, suits between center and the state. Maharashtra political problem due to lockdown, there is the CM cannot be elected as an MLC. Yeah, so I've vaguely read about this, but I haven't yet properly. So I don't yet have a firm view on this, and I need to study it more before I develop an opinion on this. I have some vague sense, but I haven't yet this carefully. So I'll need to read up more before I do this. Concern only about the backing of the law, which has not been mentioned by the government, because maintaining public health pandemic is unquestionably a legitimate aim of the state. Dental college. Yeah, no. So I think the dispute is not around the aim. So everyone agrees that the aim is legitimate, and everyone agrees that the choice of method, which is lockdown, is also legitimate. So you can have a political debate about lockdown or no lockdown, but not a legal or constitutional objection to it. So I think there is no disagreement. The issue is that the measures taken during a lockdown is disproportionate. Modern dental test requires a law and a rational aim at the least restrictive measure. So if you have two options open, option A and option B, both option A and option B to address the issue. Option A infringes rights more, option B infringes rights less. You pick option A and say, look, it's the more restrictive option, and that's what's wrong. Odisha High Court case, I think it's a really model example of this. Odisha High Court says that, look, you have banned all vehicular movement. That is disproportionate because disabled people, citizens, do require the use of vehicles to get, and their use of vehicles will not substantially increase the chances of the spread of COVID. The government could have had a tailored ban for disabled people and elder people to use vehicles. Complete ban. We'll step in and say, look, okay, we are going to like narrow down your ban and exempt these categories because that's the proportionate response. That's kind of like the role of the court of this kind.
Hello. Hello.
Just type it out because I'm going serial wise. Like it's like so. Yeah. The art. why not impose higher degree of punishment for people who are found to be intentionally breaking the lockdown? But there needs to be, again, you should have to. Presently, the law in question is the NDMA, which I think has imprisonment or something. So, you may want to have a law that makes it strict. Bill 21A made the right to free and a fundamental right. 1st April directed the CBSE to promote students from 1st to 8th class. Don't you think it will affect the basic right or will weaken the basic right to education? No, I think that, again, I think an educationist is better positioned to answer this. It seems to me that and you can't give exams and you can't do what has to be done, then it seems to me that this is one of the many options the government might. Whether it will affect the right to education, I think I don't really know, and I think that that's more of an educational policy question and less of a. India Setu might be the new Aadhaar linked in the future. I think that there's a very strong chance that week or 2 weeks you will have a link between Arogya Setu and Aadhaar, and I think that's soon because there's a great similarity in how they're being pushed as part of the government's overall belief that data must be centralized and located in a central repository to which it has access to. So I think that you will actually see that soon. I find it problematic that some photos have come showing RSS workers were working alongside those who punish the lockdown. So of course that's the problem. The police is a state body and should not be supplemented by a private. Who will police the police within the lockdown? Yeah, so I mean, again, that's exactly where you need to have a judiciary because police excesses are best gated in court because there's a clear law that tells you what the police can do and can't do, and a breach of those laws, and so that has to. Like the issue of privacy, can the law of prior restraints imposed upon circulation of information by various state governments affecting the freedom of speech, hampering the right beyond the pandemic? Yeah, so again, this is a general issue that measures you pass during an emergency have a habit of entrenching themselves permanent part of the legal landscape that goes beyond the emergency. Even the 44th Amendment to undo Indira Gandhi's changes, a part of them. It didn't undo the whole gamut of changes she made. It's very important to be vigilant and to ensure that these measures remain temporary. And one way of doing it is to have a legal or constitutional requirement that any measures taken during an emergency automatically lapse with the of the emergency, but like an ordinance, actions taken ordinance lapse with the ordinance's end, unless you have some exceptions there. But that's basically the idea. So to understand this is temporary is a very important, I think, be specifically written down in law and not left to the discretion of the government. The CSR contribution be used for the public health. What is the constitutional account? So I think that the issue is again a more political one, in that CSR contribution is there for the PM Cares account, but not there for the state relief funds. And again, this is more a question of corporate law and corporate governance, so I'm not the best person to answer it. But my understanding is that it's quite discretionary, the decision of what qualifies as CSR and what doesn't. And of course, if it's arbitrary, you can challenge that. And this, of course, does seem in some ways to be a little arbitrary. So there's the issue about the releasing of personal data, which I've spoken about already. Private vehicles, a lot of crowd will come out. At that case, will the court take responsibility if anything wrong happens? That many times courts who don't have knowledge of ground condition are breaching their own boundaries. Yeah, no. So I mean, like, it's obviously a fact that the courts don't have an understanding of ground level conditions, which is why I think the point of the state is to apprise the court of what's happening on the ground, so the court can take a more informed judgment based on inputs given by the state in the form of affidavits, and so on. I think beyond that, on the other hand, the issue is that this on the ground, the law has to be uniform for everyone, right? And so, the job ultimately is enforce the law, and the states ensure that the implementation on the ground is does not cause problems. It's a bit like the whole idea of assembly and protest, right? So you have a right to protest, right? And job to ensure that people don't come along and attack you physically for protesting. The state can't say that, look, if you protest, your cause, someone else will come and beat you up, and we can't take responsibility for that. So mind what you're doing. The argument. The issue is that the court's role is to enforce and the law, and the state's role is to then implement down, and that's the division of responsibility that the constitution envisages. Decide on the question about individual liberty and public health, which we can see in countries like Brazil, US, and somewhere in India, where we can see that coming out on the streets, the idea of lockdown. Yeah, I mean, so this is obviously a big problem, and again, this is more a question of social culture. And if people think to the lockdown requirements, then beyond the point, there's not much that the state can do, honestly. So it really requires scale. It requires cooperation less than kind of top-down enforcement. Changes like introducing video conferencing of rape cases where the victim might be vulnerable to trauma or near the accused lack pragmatism. To suggest. Yeah, so I mean, I think this domestic violence issue is really a very, very difficult one, and you're right in that video conferencing becomes hard if you're in the same space, which is why there's been suggestion that you reverse the Domestic Violence Act, what happens under that, and ensure that the woman can stay in the household, and it's the violator or the abuser who has to find different accommodation. And that might be one way to get around this problem. Migrants have talked about. What is your opinion about fake news right now? Like some media houses, like National Herald, are owned by some parties, and many times they have spread fake news and any time reveals caste and religion of someone. Two different things. The revealing of personal details, which I think is a privacy violation and that requires legal action for that. So that's one issue. Second is fake news, and that's a much more difficult issue because it's very, very hard to define what fake news is, and at what point does the border begin between facts, which can be right or wrong, and opinion, which anyone can hold. You have a right to your opinion, but not to your facts, because facts, are not a matter of opinion. It's very hard to implement in practice. With fake news laws is that ultimately they become very subjective, and the government then decides can and what is not. That's something to keep in mind when you're thinking about a fake news law, because that problems then it solves. There are lockdowns within lockdowns. I have just been informed that in Jabalpur there will be a complete lockdown till 27th April because of 16 new cases being detected tomorrow. Yeah, today. Yeah. So this is the thing. So the central lockdown is only a threshold. It's a floor requirement. The state governments cannot loosen it further. But based on the situation in individual places, governments can impose the Epidemic Diseases Act to have a stricter lockdown. That's what's happening here. If there is lockdown, then that is what's happening in this case. We know the Supreme Court in Puttastami judgment said that there is a need for data protection law in this country. How would this law be helpful for the government and individuals' private information from spreading? Yeah, so a data protection law basically defines categories and classes of sensitive personal data. It includes details and data which you can use to identify someone. Right? Law then puts very strict that data can be made public or shared, and it has penalties for breach. So, in that sense, the strong law can ensure that of personal details only in the most exceptional of cases, strong penalties for breaching that. To the impact of current situation, human rights regime in a post-COVID-19 India, we already had CAA protests has increased, consumption of child porn has increased, making children vulnerable, and so on. Yeah, so I think that as you've said, this issue of domestic violence and so on has really spiraled during COVID, and it really has shown many of the collateral impacts of the lockdown. Shown us that we need to then rethink many of these issues, because if a lockdown leads to more domestic violence, then clearly there is something wrong with the legal framework designed to check that. So that's one thing. As I've said before, I think to ensure that in the post-COVID world, right, the measures taken to deal with COVID don't carry on into the present once the pandemic is gone. Then we go back to normal legal standards and rights and so on, because we all accept that you need restrictions to COVID is tackled, become like a permanent feature of the legal landscape. I think that's it. That's all there is. So thank you to everyone for this session. I really enjoyed questions, all very good questions, and I hope that the discussion was also of some enjoyment and use to you, and that we have many more such discussions during this quarantine period and think more about these issues, as you go on, because they're all really, really important issues that I think it really shows how constitution and constitutional rights are not abstract, things in the air, but are relevant to daily life, specifically in a time like this when you have a public health crisis. So thank you for your time. Yeah.
Before I request Manindra sir to give a vote of thanks, let me quickly add something. Personally grateful to Gautam sir for generously accepting my invitation. Sir, I feel intellectually enriched after listening to you. I now understand the importance of constitutional goals in such a hard time. Thankful to you, sir, for taking out some time for us from your busy schedule. Thank you so much, sir.
Thank you for inviting me. It's always a delight and a pleasure to engage with, especially our students, as as student and as sharp as all of you are. Like it's a genuine pleasure for me as well. Thank you.
Since Shubham has already done the task of giving the vote of thanks, nevertheless, I thank Gautam most importantly for having spared his valuable time and talking to us on such an important topic that we all need to discuss and grapple. I would like to thank Gautam also for kind of rekindling this students' interest in something like constitutional law. Generally, it is said that national law school students are more interested in corporate law, IPR, and all. Yeah, happens to be the torchbearer. It seems that who has rekindled the students' interest, especially national law school students, in a subject like constitutional law. So, thank you very much, Gautam, for having done that, and thank you all of you, my students, for having participated in this webinar, and also to the organizers, Shubham, and to all the faculty members who have also spared their valuable time. Thank you, and we look forward to having you even in future as well. Thank you very
I'd
much.
love to physically be there sometime after all this is over. So yeah, see you.
Most welcome, sir. Thank you so much.
Online is on.